So hopefully you can just all see the disabled children in the law PowerPoint slide. Sarah, can you see that? Can you just confirm that? No, that's
you
great.
are good,
Okay.
Luke. Thank you.
Off we go then. Let's go. Some of the first few slides are ones that I will have used on the last occasion, so I'm sorry about that repetition, just in case you were here then. As you see at the bottom, I've got a website, and it's quite a useful sort of go-to place because I tend to post lots of materials on the rights of disabled people of any age and their carers, which reduces the sort of my workload a bit. It's that material. So if you go to that and you look, for instance, at this page, which is the resources tab, it's got lots of sort of bits about that you can click off and get fuller details about rights. There's quite an extensive list there. I've got a whole series of recorded lectures and presentations which may or may not be useful. I try to put all the publications I've got on the website. Most of those are free to access, not all of them, but if you click on that, you'll get recent publications. You can scroll down there. And probably one of the most useful documents for today is going to be the Disabled Children's Handbook. That's a book of about 600 or 700 pages that I write with a barrister, Steve Broach, and that's free to download. The Council for Disabled Children pay for that, the publisher, to download that. The edition is 2020. Not much has changed since 2020, but Steve and I are currently about to produce a new edition, which I suppose will come out the end of next year. And so if you click on that, you get the book, well, you get the individual chapters of it, that book. Every so often I write a publication for Carers UK. It's about 100 or so pages about rights of carers. We're going to be looking at that today. No, we looked at that on the last occasion, sorry. You can download that, as I say, about 100 or so pages, and that's free to download. I'll be mentioning today the Accessing Public Services Toolkit. That is free to download. It's been downloaded 50, 60,000 times. It's quite a short document that explains how to try and solve commonly occurring problems that disabled adults, disabled children and their carers encounter. And that's just a recent book I've written, which isn't free to download, but it's mercifully brief and not terribly expensive. So that's the program today. We're going to look at transitions into adulthood, rights of young disabled adults, which is going to be a quick, well, I'll rake through that pretty quickly, although it's a very dense subject, but hopefully will be useful. And likewise, mental capacity and decision-making, huge topic. But again, I'll rake through that relatively quickly, I'm sorry to say. And then I've just got a very short bit to talk about law reform. The previous government asked the Law Commission to look at reforming the law for disabled children's rights, which is long overdue. But that, although it's a really useful development, is not going to happen for the actual reform of the law, won't happen for 4 or 5 years. So it's something to be noted with interest, but not to see it as a panacea for current problems. So I'm going to kick off with transition to adulthood. And transitions into adulthood is basically a young person and their carers moving between two pieces of law. They're moving between the Children Act, which governs the rights of disabled children, carers of disabled children, moving from that responsibility to another act, the Care Act, which is an act that governs the responsibilities to disabled adults and their carers. And that transition has happened, existed in the law since 1991. And it's pretty it's very commonly a pretty dreadful experience, because you're moving from one organization, effectively one department, to another. And I've just put some quotes in from what the Ombudsman has said about the way transitions are handled. She said that it was not untypically public bodies fail to comply with the law. Even if the transition process is instigated, it is frequently characterized by delay, officer turnover, people make promises and then they leave, a lack of incisive action, broken undertakings, ignored complaints, persistent failure to locate suitable placements, where councils lose the ability to look at the whole child and his or her spectrum of needs. They become particularly insensitive to the impact this is having on family carers. And for those of you who have been through the process, you may recognize that. Sometimes it happens incredibly well. You have transition officers, but all too often it's a fraught experience. So one of the things is to sort of try to conceptualize how transitions can be envisaged. And I used to sort of talk about, and people often do talk about, handing the baton over, children's services handing the baton over to adult social services. And of course, that's quite a neat scenario. But the problem is that we always remember that the baton is dropped. And that's traumatizing, and all too often that baton is dropped. So I was sort of trying to think of another way of conceptualizing it, and I thought about, because I work in Leeds and I go past the Leeds-Liverpool Canal all the time, like a series of lock gates where you're moving the boat from the pond, really, or whatever it's called, at the bottom of the Children Act, and you've got to get it to the top where you safely berth it under the new regime, which is the Care Act. But again, if you look up that sort of stuff, you end up with horror stories as well as these images explain. So it's not a great image. And the way I envisage transition is that it's not a legal problem. It's a management issue. It's about these two organizations working together and making the arrangements. And children's services and adult services are, what I'll be saying is that they're pretty good at long-term planning, producing a glossy document about what will happen in 5 years' time, maybe. And they're quite good at, they're really geared up to respond to crises, but they're not very good at medium-term planning, where you've got to do something within a year or two and you've got to sustain it. So you've got officer turnover, you've got changes all the time in the management regime, and that's the problem. And, you know, of course, that is exacerbated by chronic funding problems, which they've had for the last 15 years. Reorganization, staff turnover. And as I say, largely they only respond effectively or not even effectively, but they do respond to crises. So, as I've already said, you're moving, the individual's responsibility is shifting from the Children Act, and also I think all the Chronically Sick and Disabled Persons Act, which is specifically a piece of legislation for young disabled people. And you're moving, those acts we'll see effectively stop at 18, but we'll see that they don't actually stop at 18. And you're moving to a new department who have responsibilities under a different act, the Care Act. And what I'm saying is that this is a management problem, and unfortunately, families are going to have to get involved in that management problem. And I think the way I would start with a transition is to say, look, this is what I want. Let's say I've got a disabled child called Alice, and she's got quite high needs. I would just sit down and say, what would I ideally want to happen once she becomes 19, 20, 21? And as I say there, I could envisage that by June 2019, this shows you how old this slide is, I'm sorry. By June 2025, I suppose is the date, Alice, I want her to not be living in my home, but to be living close by, in walking distance, in supported living, and that to be an environment where people of her own age and interests are also living. And this is the support she'll need, and we'll need a care plan. We'll need a detailed care plan about how that will operate. And there's probably no supported living that meets that need in my locality. So I'm going to say to the local authority, well, this is what is going to happen. And you're going to have to go out and commission and recruit and, have a contract to provide suitable accommodation. And so once you know exactly what you want, that's what you're going to be pushing for. It's not a question of asking the local authority what do they normally do or what are the options. It's to really work out what would be ideal for Alice. And the law will say that is really what the local authority should do within reason, of course. If you want her to live in something exotic with swimming pools and things like that, that may be a bit much. But just to say that this is reasonably what she would need, and we need, and it needs to be close, and that she needs to have independence, she needs to socialize, and so on. And of course, that's going to be very different for everybody, but really the family and the disabled person are going to be best judges of what that is. One of the things we said, and I refer to this in the problem-solving toolkit, is that when you're asking a local authority to do something that isn't routine, like putting in a care assistant or paying a direct payment or something like that, it's what we would often call a sort of too complicated to think about, and we talk about that in the problem-solving toolkit. When you're asking the local authority to do something that is out of the ordinary, to craft a tailor-made package, then they're going to sort of that's the file that they put at the end of the desk. They'll deal with the easy emails, they'll deal with the easy problems, but this one will just delay. And one of the techniques in problem solving is to realize that their problem is not just their problem, it's your problem too. So in a way, it's incumbent, if you have those networks and skills, to come up with suggested solutions. And to say, and to go out and talk to providers, talk to housing associations, talk to other people to see what can be done. Talk particularly amongst parent carer groups about what would be an ideal facility and so on, and then to lobby for that facility to be commissioned or for a name, for your child's name to be put on that waiting list. I often think it's about like renovating a house. You've got a house, it's dilapidated, you just bought it, you want to do it up, you need a builder, a plumber, electrician. Most of us can't afford an exotic architect, so we have to project manage that ourselves. And of course, plumbers, builders and electricians are very good at their job, but they're not very good at coordinating their work with other professionals. So that's a role in a way you have to do, because it's often coordinating it between education authorities, healthcare workers, housing providers, social care, children's care, adult care, and so on. And it's unfortunately something that, unless you roll your sleeves up and take on that role and keep copious notes, is all too often not going to happen. Obviously, if you're in an authority with good transition workers, that's their work, that's their role to work between these two, 3, 4, 5 silos of the state. And of course, keep notes on everything that was said. And if it's spoken, then the question really is to put in writing immediately in an email. Today, I spoke to Mrs. Smith, and she said that this would be done, and she would discuss this with so and so, and it would be put in place by 2 weeks today. You're laying down records of what commitments and promises said, because Mrs. Smith may go off sick next week, or she may be reorganized into another department. And the issue is to complain if things that are said are not done. In our problem-solving toolkit book, which I'll show you in a minute, we have sort of touchy-feely complaints. I'm making a complaint. I'm very happy with my relationship with Mrs. Smith or whatever, but this was a promise that something would be done, and it hasn't been done, and I'm worried about drift. I'm worried that delay will happen. And so I'm putting in a complaint so that this doesn't happen, because of course young people don't hang around for local authorities. They are, you only get a childhood once, you only get your transition once. So the only way to, and the biggest danger largely in transition is delay. Promises are made, commitments are made that are not honoured. Honourably, people go off sick, they change jobs and things like that, and you drift. And after a while, you suddenly realise a year's gone by. So that needs to be put in a complaint form. When we come to look at the problem-solving toolkit, you'll see that there is a precedent complaint that says, I don't want to disturb my good relationship with him, but I'm worried about delay and so on. So it's in a way drawing up a plan saying, for this to happen, for Alice to get her supported living placement close to us with people of her similar age and interests, social services, housing, education, the NHS have got to work together to do these things. And then spelling out that what each of them needs to be done with a clear timeline. This sounds incredibly demanding, and I suppose in a way it is, but it is a crucial moment where care plans can be put into place and sorted out, which will be good for the disabled person and for the family for perhaps decades. So it's all hands to the oars sort of thing. And we need a plan. We need a plan. And there's no reason why a local authority, they might say, well, it's very difficult. We can't find a housing provider. We can't do this. We can't do that. And the answer is, well, let's have a plan. And this plan will say that within 2 weeks, you will speak to every social care landlord in the area. You'll give us a list of all supported living providers. You will contact all those supported living providers, and so on. There's nothing to stop them producing a plan with commitments to do things within time, even if the actual concrete service is not readily available. On my website, I've got I do sort of what's new updates, and a few years back I wrote I posted a note on what's new about how you resolve difficult questions, not easy questions. And the answer is that they require a plan. And so if you click on, if you go to the website, you'll see there's a posting there talking about that in generalities. And as I've mentioned quite a few times, on the Accessing Public Services Toolkit, which you can easily download, just Google it or go to my website, you can download it. That's got a lot of information about what you do in these sort of quite difficult to resolve issues. And likewise, complaining, I think in areas like this, you have to do it in a nice way, but early, because if you wait, many people just wait because they hope that these commitments will be fulfilled, and the local authorities genuinely trying to do it, but it's just got staff turnover and reorganizations and God knows what. So it's good to put it in early, because then you get onto the complaints conveyor belt, which has got time limits to look at these things. There's a precedent on the problem-solving toolkit. And of course, the complaint spells out what hasn't happened, what a reasonable public body would have done. And in a way, the most important thing about a complaint is to say not only what hasn't happened, but to spell out very concisely what you want to happen as a result of this complaint, so that they know very clearly that that's what needs to be done. And of course, the deadline. It's often good to use the word maladministration. It's one of those magic words we talk about in the problem-solving toolkit and sometimes to quote a snippet of law, not too much, just an ombudsman's case. And all of those can be downloaded, the snippets of law, the word maladministration, and ombudsman's cases from the Accessing Public Services toolkit. So that spells out in a way, and it's got precedents for these complaint letters. So transitions have been dealt with by the law as well. As I say, you're moving from the Children Act to what is today the Care Act, and there are, under the new legislation, which came into force, I call it new, but it came into force in April 2015. So for an elderly gent like me, it's new, but for most people, it's always been that way. You have sort of various milestones. When the young person is 14, if they have a education healthcare plan, then transition planning should start. Transition planning should start in the sense that the education provider should invite social services to the next meeting to talk about transitions. But all too often, social services all too often they aren't invited, but the law says they should be. But all too often they say, well, this person isn't known to us, and so they don't attend. So that key date, even if you do have an education healthcare plan, is often disappointing at the very least, unless that there is very significant involvement with social services at that stage, children's services. But the other stages are sort of mandatory for everybody, whether they have an education healthcare plan or not. And that's at the age of 16, 18, and CM stands for convenient moment. And I'll explain how this happens. So you have a disabled child or their parent or their sibling, because if you're a parent caring for a disabled child, you have rights under the Children Act. If the child becomes 18, you don't have any rights under the Children Act anymore. You have rights under the Care Act. So they're going to be transiting through this change from one act to another, as would a young carer who becomes 18. Those three people, as they're going through, basically, when the person gets to about the age of 16 or possibly 17, there's now a duty on the adult social services team to assess them and to tell the family what, if any, support that they will get once the young person becomes an adult. So that and when that happens depends upon the extent of the need. The more complicated, the more extensive the need, the earlier it should happen. We'll look at an example of that in a minute. And so when the young person becomes 18, the young person or the parent carer or the sibling carer knows what support will be available from the adult team. But that doesn't immediately kick in because the adult team may not get around to assessing it, may not get around to putting in place all of those supports that it's supposed to do. So what the legislation says is that even though a young person has become 18 or the parent caring for the young person is now caring for a young adult, the Children Act responsibilities continue until a convenient moment happens when the adult team will take over. So if there's any delay or there's any problems, issues, there isn't the support from children's services doesn't stop. It only stops when the responsibility is accepted and implemented by the adult team. And at that stage, the support comes from the adult budget. And there's a general formula which says that a local authority must undertake a transition assessment where it's likely the young person will have care and support needs after transition. So it doesn't mean that they're already getting services. If they're already getting services from the disabled children, from the children's team, it doesn't have to be from the disabled children's team, but from the Children's Services Authority, then it is likely they'll have support needs. The Act says that. But even if they're not, because they're living at home and the family is providing everything, but the family is saying, look, we want the young person to move into supported living or something like that, then of course, if the family is saying that, then it's likely that they will have care and support needs. So that's triggered. And the second criterion is that it's got to be of significant benefit to be assessed. And that is not talking about whether they're assessed, it's when. When would it be best to assess them? And if it's just a question of the adult team taking over direct payments, then it might be something that can be done when the young person is 17. But if it's something more substantial, then it's going to be of significant benefit to do it much earlier, so that there isn't then this sort of huge delay once they become 18. And if the adult social services team say we're not going to assess, they must give rational, detailed, evidence-based reasons in writing to explain why that is. And there's an interesting case example given in the guidance to the adult legislation, the Care Act 2014, which is really the legislation talking about transition these days. And they talk about paragraph 16.15, Isabel's story. And she's a bit like the Alice case I talked about. She's 15 years old and she has complex needs. She attends a residential school during the term time, and that's jointly funded by Education and Social Services. And she gets social care at home during the weekends and in holidays, adult children's services during the holidays. So Isabel's parents approached the local authority for a transition assessment on her 16th birthday. So 2 years ahead of where this is going to happen. And initially, the local authority says that it's too soon to be of significant benefit, since the support from the school continues until she is 19. They feel that transition will be straightforward, as adult services simply need to begin funding the package she's already getting. But the parents say that when Isabel leaves school at 19, it will be appropriate for her to live, it will not be appropriate for her to live with her parents, and she'll be required substantial supported living and a college placement. So this is the sort of case I've been talking about with Alice, that once the young person becomes 18, she's going to be needing a supported living placement. That's a much bigger social care plan to put together. And this is just a sort of fictitious scenario, but as the statutory guidance says, that due to the nature of her needs, she will need a lengthy transition in order to get new staff and a new environment, a new placement, educational setting. And so it is appropriate it is therefore significant benefit for the transition assessment to take place around age 16, looking at both the funding for support and the longer term options. So that's a very good example, because that's in statutory guidance. Statutory guidance is sort of almost law about what should happen in these situations. So hopefully that talks through that. The statutory guidance to the Care Act says that well, I mean, that's fairly straightforward. It's just about what the adult team must do when they assess. They must create a care and support plan and a personal budget and tell the family this is what's going to happen. More importantly, I think, well, just as importantly, the Children Act, Section 17ZH, enables adult social services to decide the best time to transfer their responsibilities. And the Special Education Needs and Disability Code states, under no circumstances should young people find themselves suddenly without support and care as they make the transition into adult services. Very few moves from a children's to adult services will or should take place on the day of someone's 18th birthday. And the Care Act, well, Section 17 says that they can continue to be provided under the Children Act and the Chronically Sick and Disabled Persons Act, even though the young person is now over 18. And the statutory guidance to the Care Act says families must not be faced with a gap in provision of support on the 18th birthday. If by that date the necessary support is not in place, then the services must continue until the relevant steps have been taken. So in theory, the law is in good shape. The problem comes around to making sure that the adult social services team do the assessment in a timely and adequate way, do produce a care plan that is in the best interest of the young person and realistic, not the easy, well, this is all we've got. So the sooner they are required to go out and look at the options, and that requires, I think, the family and the young person to spell out that this is actually what we want. And I know you don't do this at the moment, but you're going to have to, because this is what is in the person's best interests. It's got to be person-centered, not, we've only got 3 options, you just got to choose one. It's not about existing pigeonholes. Often it is about going out and creating person-centered plans. So that's the statutory guidance to the Care Act. Very useful. You can just Google that. And that's very useful to quote in discussions if a local authority is saying, well, we don't do that. And again, read the Accessing Public Services Toolkit, which talks about the "we don't do" phrase in unlawful in general for local authorities to say that. Okay, so I've rattled through that. I don't know if there are any quick questions to take on that. I can look at the chat functions in a minute. Well, we'll probably break in about half an hour. But if there's any pressing question, I could take it now. But absent that, I'll, as I say, in about just after 11, I'll look at the chat functions and respond. So the next issue I wanted to have been asked to look at are the social care rights of young disabled adults. So these are people who've been through the Children Act, Children's Services System, and they are now on the other side of 18, and they are now being assessed by adult social services. The regimes at the moment are very different. adult social services are much more formalized. Often the support is less generous because the support should be exactly the same, but the problem is that the criteria for adults are largely based on older people who often get fairly small packages, and therefore when a young person comes across the 18-year threshold, they might have expectations of a much more richer care and support plan because they have a whole life and activities that they need to do. So we have, and as we've already seen, that the children's legislation for disabled children is a mess. Even though in theory it's got some very good rights for disabled children, the arrangements are, in my experience, pretty dreadful. And they're not great in the adult social services, but at least in adult social services, you have a clear set of rules and regulations and eligibility criteria. And hopefully that's what the Law Commission, well, I'm sure it will do when it reforms the law for disabled children. But as I say, that's going to be at least 5 years away. So what are the rules once a person is the responsibility of the adult social services team? Well, they're subject to the Care Act. And the Care Act has an extensive list of principles that are guiding principles. And in a way, the Act makes clear, Section 1 of the Care Act makes it clear that the overriding duty on adult social services is to promote the well-being of the disabled person, as well as to promote the well-being of carers, the people that care for adults in need. And it has this long list of what well-being is. It's personal dignity, it's physical health, mental health, emotional well-being, protection from abuse and neglect, control over your life, having choices, participating in work, education, training, and you can see that it's a long list. Being involved in the community. I pick out those two really as, I think, principles that we often refer to when we're challenging local authority decisions. Control over day-to-day life means that people should have choices, and that's particularly relevant with things like direct payments, which are becoming very, very rigid in what you can and what you can't do. And if you don't do it, then you've got to repay the money and things like that. And the reason I highlight participation in work, education, training is not just because that's very important for young disabled adults, but these well-being principles apply to carers too. So what the legislation is saying is that carers of disabled people have just the same right to work as people that don't have to care for disabled people. There's no obligation under the legislation in the UK to provide care for an adult. Therefore, if a carer says, well, I'm not going to do that, I want you to provide 24/7 care for this person, ideally in my house or in supported living, I'm going to go back to work, then the local authority must do that, because the overriding well-being principle says that carers have a right to work, to go back to college, to go training, to have recreation. And the well-being principle is then further fleshed out by saying A, B, C, D, E, F, G. These are what well-being means. And I think the first one is very important, is the assumption that the individual, i.e. the disabled person or the carer, is the best judge of what is best for them. And if the local authority wants to say, well, we don't think that is their best interest, the local authority will have to come up with powerful evidence-based reasons to suggest why their view should be preferred. One of the principles that's not in the Act, but should have been, is the principle of independent living. And that's because the Act comes into force the Act was enacted by Parliament in 2014, but in 2008 the UK ratified the UN Convention on the Rights of Persons with Disabilities, and Article 19 of that convention says that a fundamental principle of that convention is that states should promote community living, independent living. They shouldn't unnecessarily institutionalize people in care placements and care homes and so on. Now, the UK signed that in Geneva. It made a public proclamation that it will do everything it could to promote independent living. And then it passes an act, and it's completely silent on that. So that's a clear breach of its international promise. It's bad faith. That was when the Act was going through, a number of us kicked off about that. And the statutory guidance, in a way, rectifies that problem. The statutory guidance, which is almost law, says at paragraph 119, the well-being principle is intended to cover the key components of independent living as expressed in the UN Convention on the Rights of People with Disabilities. In particular, Article 19, supporting people to live as independently as possible for as long as possible, is a guiding principle of the Care Act. So that's something that's important to refer to if you're having a problem with a local authority not providing the person's choices, because Article 19 of the Convention has really three principles. The first is that individuals should be able to choose where they live and with whom they live on the same basis as the people that aren't disabled. So they shouldn't be unnecessarily parked or put in care homes or placements that they don't want to be in. The second principle is that local authorities, the state must provide a good range of high quality services to support people to live in the community. Personal assistance, direct payments, adaptations, sitting services, and so on. And the third principle is that all general facilities in the community should be as accessible. So things like bank machines or accessible toilets or restaurants or working conditions that make reasonable adjustments and so on. But it's a second principle about having high quality services, which is really important. Independent living means that an individual is given good quality services and supports so that they can then live independently. They can have interpreters or care assistants or equipment and adaptations, so they're on the same platform as people that don't need those supports. And once they've got those good supports, they can then live independently. Sometimes local authorities seem to define independent as not being subsidized or supported in any way. You're living independently. You don't need any help from the state. And that's not what independent living means. It means people are given good supports so they can then participate on an equal basis with others. And that principle, which is in the UN Convention, has been referred to by quite a lot of courts as being sort of effectively a principle that is part of domestic law. Once a disabled person comes to the notice of a local authority, once a disabled adult comes to the notice authority or their carer, then there's a duty on the adult social services team to assess. They don't have to ask for an assessment. The duty to assess is triggered by the appearance of need. So once the person is known to the adult social services, there must be an assessment. But of course, if a request is made, then of course the person will be known. And this applies not just to the adult in need, the disabled person, but also any carer The assessment should be an open process so that copies of all the assessments should be shared with the disabled person and care plans. And the Ombudsman has recently said that drafts of assessments and care plans should be shared as well, because all too often assessments just contain inaccurate data. They get the names wrong, the dates wrong, sometimes they get the sexes wrong, and facts. So it's important that there's a complete sharing of care plans, because we all make mistakes when we're writing stuff down that we're not familiar with. And the big difference, I think, with children's services is that we have very clear eligibility criteria for adult services, and these criteria are in law. They're in the regulations approved by Parliament. Disabled children's services do have eligibility criteria, but they are completely incomprehensible. They are sort of spreadsheets which are sort of banded red, green, yellow, blue, level 1, level 2, level 3, level 4, and all that, just completely subjective and arbitrary. And that is going to have to go. And I'm sure the Law Commission, when it comes to say there will be just one simple standardized criteria for everybody in England who is a disabled child or a carer of a disabled child. As I say, we do know very clearly what the adult criteria are. In each local authority has got different eligibility criteria, and they're all opaque and highly subjective. And the way to understand how one should interpret the eligibility criteria is to look at them through the lens of well-being principle. Now, it sounds a bit fancy, but if I can sort of explain that briefly. So the criteria to access adult social services are laid down in the regulations, the Care Act eligibility criteria regulations. And that is basically just a three-stage process. There are three hurdles, effectively, that the individual has got to cross. And the first and the third hurdles aren't particularly difficult to cross. The second one is the one that we have to sort of scratch our heads about when we come to. So the first hurdle is that the person's need has got to arise because of a physical or mental impairment or illness. So the need hasn't arisen, the need for support hasn't arisen, let's say, because of domestic violence or something like that. It's got to arise out of the fact that the person has a physical or mental impairment or illness. Normally, that's not going to be an issue. It doesn't have to be a diagnosed condition. If the balance of the evidence is that the person has got autism, even if they don't have a diagnosis, or they've got ADHD or whatever, then it's just on the balance of principles. And if the evidence suggests that, there should be an assessment. And normally that's not going to be such a problem with adults. And the courts have said it's a very low threshold of evidence. The second hurdle is the more challenging, that as a result of that physical or mental impairment or illness, there are at least two things on a list of 10 that the adult can't do. So we have effectively a list of 10 activities of daily living that are considered important. And if the adult can't do two of those, then they are eligible for support. And we'll look at those 10 things in a minute. And the third thing is that because they can't do one of those two of those 10 things, that has a significant impact on them. That's not particularly difficult, because the presumption is that if you can't do one of those two things, it is significant. But the local authority could say, well, in your particular case, even though you can't do these two things, it's not significant because, and then they would have to come up reasons why in an individual case not being able to do one or more of these things isn't a problem. And when the legislation says you can't do one of these activities of daily living, the can't is expansively defined. It's not that you can't just do it. It's also you can't do it without assistance, because we're only looking at you. And if you can't do it, then it can't be done. You may be getting some assistance, but we're going to look at that differently when we come to see when we do the carers assessment, because that person may not want to do it. There's no obligation on anybody to assist you under UK law. So if you can only do it with assistance, actually that means you can't do it. Or if you could do it, but it would cause you pain, distress, or anxiety, then you can't do it. Or you can do it, but it would cause health and safety risks to yourself or others, you can't do it. Or if it would take significantly longer. So yes, you can dress yourself, but it would take 3/4 of an hour, something like that, then you can't do it. And then we have this list of 10 things that are considered essential activities of daily living in effect. And if there's 2 or more of those that you can't do, then you're going to be eligible. The regulations, just that is the list in the regulations. But of course, what does managing and maintaining nutrition mean? What does being appropriately clothed mean, and so on? And those basic statements are fleshed out in what's called the statutory guidance to the Care Act. And the statutory guidance to the Care Act, which you can just Google and download, has effectively the force of law. So this is fleshing out a simple statement made by Parliament, but the additional words also are things the local authority got to do. And the guidance in paragraph 6.106 explains what each of those simple statements mean. So one of them is managing and maintaining nutrition. And I'm just going to give you some examples. So what does that mean? Does it mean you've just got to be given support so you don't die of starvation or dehydration? And the statutory guidance fleshes that out by saying, well, actually, it's whether the adult has access to food and drink to maintain nutrition, and that the adult is able to prepare and consume the food and drink. Well, consume is the prepare is quite a big word. So this isn't just a question of the local authority delivering every week to somebody 7 days supply of pre-cooked frozen meals plus a microwave. Because if the adult wants to be able to prepare food, they've got to assist with that. So this is, in a bit like independent living, not being fed, but being taught how to feed yourself. Preparing food would require you gathering the ingredients, so that would include shopping. You might need some help with that, and so on. So these criteria, the definition is quite expansive and quite rights-based. So we have a case on that, and I'm only going to give you a couple of examples just to sort of explain how this works. So we have a woman who's recently become blind, and she says to the local authority that she needs help in relation to this activity, because she needs help, among other things, to check the contents of her fridge, read cooking instructions, and have an escort to help her on occasional shopping trips. And the local authority say, yeah, that's true. That's managing, maintaining nutrition. But you don't need to have this sort of exotic help getting you checking the contents of your fridge and reading cooking instructions and going out on occasional shopping trips, because you could adequately eat meals. You eat long life foods, use your freezer and ready-made meals. Now, when a local authority responds in that way, saying, well, yes, you want to do these things, but there's another way of doing it, and that's perfectly adequate. what one needs to do then is to go back and look at the well-being principles. And there they are in summary. And to say, well, that's all very well, but that doesn't enable me to do, that doesn't promote my well-being. And you have to look, therefore, at one of those principles that it doesn't enable you to do. And often it will be fairly straightforward. Personal dignity, often things like that, or control and choice. In this case, the Ombudsman looked at physical and mental health, and mental health. And what he said was, it's unlawful for a local authority to fail to recognise that fresh food is essential to meet nutritional needs. The consumption of fresh food, once it has started to perish, carries significant health risk. And effectively, what the Ombudsman is saying is that the government is really pushing eating fresh vegetables and fresh food all the time. And this local authority is saying, well, everybody should have fresh food unless you're in receipt of social care, in which case you shouldn't expect to have that, even though it's essential for your physical health, because we'd prefer to give you pre-cooked stuff. So it's that way of saying, well, that isn't meeting what the well-being criteria require. So one of the outcomes also is being appropriately clothed, and the guidance says that you should consider the adult's ability to dress themselves or to be appropriately dressed, for instance, in relation to weather or to maintain their health. And it was the same case of this blind woman, and she said she needed help to, among other things, sort clothes so she didn't wear stained or inappropriate clothing. And the local authority said, well, yeah, that's fine, but it's not significant. You're still not going to die of hypothermia, basically. So again, you have to go back and look at the well-being criteria and say, which of these criteria does that response not support? And of course, I don't think it was very difficult. Most of us would say, well, that's dignity. If she doesn't know whether her clothes are stained or inappropriate, or whether she's wearing a mismatching clothes, she'll be lacking in confidence. She will be, or even if the clothes are not stained and so on. And the Ombudsman says that again. It's unlawful for a local authority to fail to recognise the importance of an adult's personal dignity, wearing clean, presentable and appropriate clothes. So I'm not going to dwell on that much longer. I'll look at this one because I think it is one that's cropped up a lot. So the guidance talks about maintaining a habitable home environment. I mean, no, the regulations talk about maintaining a habitable home environment. So that's fleshed out by the regulations, by the guidance, which says whether the condition of the adult's home is sufficiently clean and maintained to be safe. As a habitable home is safe and has essential amenities, so on. So we have an example here of a disabled person, and she's receiving a direct payment to cover her eligible needs. And she's been held to be eligible for significant number of hours of direct payments at a previous assessment. But on review, although nothing had changed, so her needs haven't changed, the local authority said, well, we're going to cut 7 hours a week from your direct payments. And the reason that they put forward for doing that was that those 7 hours were to cover nutrition needs and maintaining a habitable home, keeping the home clean. And their argument was that that wasn't something they had to do because she was getting disability living allowance, and that's what your disability living allowance should be used for. Well, that's interesting for a number of reasons. One of the reasons is that you can't get disability living allowance if all you want is housework. You have to have it for continuous bodily functions support. So you're not actually getting disability living allowance for housework or nutrition normally. But the Ombudsman looked at it from a different perspective and said, look, the Care Act places a duty on councils to do an assessment, decide what people's eligible needs are. And in deciding eligibility, it's what we've just said. It's a 3-stage process. You've got to have a physical, mental impairment or illness. Because of that, you can't achieve 2 or more of these specified activities of daily living. They're called outcomes. And that has a significant impact on their well-being. And this woman has got a number of outcomes that she can't achieve. So she's eligible. And those needs must be met. He says, I can see nothing in the Care Act or the statutory guidance which allows a council to require a person to use their benefits in this way. Of course, if you get disability living allowance, the local authority or PIP or one of the disability benefits, the local authority can take that into account for charging purposes, but it can't say because you're getting a benefit, they're not going to provide housework or nutrition or any of the other services. I mean, that would be a nonsense. And the Ombudsman had no problem about that. But very often families will be told, well, that's what your disability living allowance is for. I'm going to leave that. I'm going to move on, but you can read these. So once a person, a young adult is, or an adult is shown to have eligible needs, they're eligible for support, but they must also be they must already resident in the local authority area. So you've got to find out which authority is responsible. Normally that's not a problem. They've crossed the eligibility threshold. And we have this financial issue in adult social services that if you have finances more than 23,250, normally you're required to use your spend down before the local authority provides support. Care and support plans should be detailed, just as children's services support plans should be detailed. And the Ombudsman is frequently saying care and support plans should have contingency plans. That means what will happen if the care assistant doesn't turn up, or the day centre is closed, or for some reason the planned support or activity doesn't take place. It has got to be a plan B. And the Ombudsman saying that on a number of cases. Once an adult in need is identified as having a need, then the support must be put in place. And it can't be trimmed. So you can say, well, yes, you've got a need for 10 hours, but we're only going to give you 8. It's got to be whatever the specified assessed need is. That means there can be no maximum charges, so no maximum packages. So it could be 1,000, 2,000, 3,000 a week. It's got to meet the need. But of course, if there's more than one way of meeting the need, the local authority can opt for the less expensive, providing that one does genuinely meet the identified needs. As the statutory guidance says, a local authority's finances are relevant when it decides how to meet the eligible needs, but not whether to meet those needs. Right, I've rattled through that at enormous speed. I do apologise for that. The next big issue that we have to cross is mental capacity and decision making. Can we now break, say, for 15 minutes? I'll look at anything in the chat function and replenish my coffee, and I'm sure hopefully you will too. And if we could come back at 11:25. Welcome back, everybody. I'm just going to quickly go through the chat function questions. I'll rake through them fairly quickly, I'm sorry to say, because we've got a fair bit to do as well. But I actually can't read the chat function, so Sarah's very kindly cut and pasted them and sent them to me, and I hope I'm going to cover all of them. So the first one I've got is says as follows: my daughter has an EHCP. She's now 18, but wants to go to college. The local authority is saying it's no longer their responsibility to provide support or funding. But I thought the EHCP goes on until they're 25. I should sort of presage this by saying I'm not an education law expert. I'm a social care law expert, I suppose. EHCP plans do go to 25, and they cover further education and training. They don't cover higher education. So when you say college, I don't know if that means university or not, which would be slightly different. But if it's not a university, then education and healthcare plans do go on, and you'll need to discuss with one of your colleagues who is more expert on EHCP plans than me. If a person needs help, let's say accessing the toilet or with sort of personal care at a college, then that is covered by adult social services, just as it would be for a young person. The education element isn't covered by adult social services, it's covered by the education department, just as it would be for children's services. Children's social care do the social care support, but if you have educational needs, then that's covered by an EHC plan. So that should be exactly the same arrangement for adults or for children. So I don't know which bit of the local authority is saying they no longer their responsibility, because it seems to me that that's just wrong. I'll go through these, and then if there's any sort of further questions from any of the people that have asked, please chip in. The second question is, if the young adult is receiving funding support from continuing healthcare under NHS continuing healthcare rather than social care, then the local authority doesn't want to have anything to do with them. Can one make the same sort of requests from healthcare to commission some local accommodation? Yes, exactly, you can. I'm not covering that today. I mean, continuing healthcare is something that I have expertise in. The framework, so if somebody is 18 and they're getting 18 or over, and they're getting support from the Integrated Care Board under continuing healthcare, the Integrated Health Board has exactly the same person-centered planning obligations as the local authority adult social services team. You're going to need to download the NHS continuing healthcare framework, which is 2022 document. And if you look at that, there is a section on person-centered care planning. So exactly the same issues would apply. The NHS has got exactly the same obligations to promote independent living. If the young person wanted to be in supported living, for example, then of course the NHS would have to liaise with the supporting living provider. Social services, once somebody is eligible for continuing healthcare, social services don't have any obligations to that person. You're quite right as you say that. They do have obligations to that person's carers if there's an unpaid carer. But integrated care boards can be extremely difficult to deal with, and they are very rigid, and they need to be reminded that they have exactly the same obligations as adult social services. And that's somewhere I would be making a complaint early on if I'm getting pushback of that kind. Then I've got a question that says, phrases like relevant steps are very vague, seem very vague and easy to abuse. What if the department says that they've taken relevant steps in handing over to adult, but the adult department hasn't done anything? Well, the answer is in the legislation that if the adult department hasn't done anything, the children's services have got to continue providing support. And again, if you look at the Accessing Public Services Toolkit, one of the commonly occurring, perhaps the most commonly occurring problem families face is being told, well, yes, you do have needs, but it's not our responsibility, it's adult, or an adult social service says, well, it's not ours, it's children. And in those cases, really what you need to do is to make a complaint against both of them and say, look, my brain hurts, I can't work out which of these two bodies is responsible. They are not working together, the support hasn't been put in place, and children's services are not continuing to provide it. So you're going to have to make a complaint, and it's completely unacceptable for children's services to say, well, we've done our bit, because if the young person was getting services under the Children Act, then they should continue to get those services, even if they're 18, 19, 20, until such time as a convenient moment occurs for adults to take it over. So, and I'm not sure that relevant steps, I'm not sure that's in the legislation. I mean, it's when there's a convenient moment. We've got a question. Would the continuing of speech and language therapy be maintained by children's services? Well, speech and language therapy will either be if there's an education healthcare plan, it will be normally an education responsibility. Once you become 18, it would continue to be a local authority education responsibility under the education healthcare plan, or adult social services. Not adult social services, the NHS, but that's not going to be a social services responsibility. So that lies a bit outside my area, but it would either have to be maintained by the education department or the NHS Integrated Care Board. Does the Children and Young Persons Service sit with the sorry, this is Caroline's question. Does the CYPS, I'm not quite sure I understand that question. Does the CYPS sit with the DCS, the Disabled Children's Services or Adult Services? It's probably my misunderstanding. I don't know what CYPS stands for, because I would have thought.
Hello, nice.
Hi, Caroline.
Hi. Yeah, the Children and Young People Service. My son's 21, but he's been put into adult social care. But because he's got an educational healthcare plan.
Yeah.
I feel like the Children and Families Act extends support to 25.
Yeah.
So there's supposed to be Children and Young People Service, and you know, it's like, who's responsible for that? Is that adult services, or should he still be getting the support from the Disabled Children's Services?
He'll be getting, yeah, I see. Yeah. My understanding is that he'll be getting the education support from the education wing of children's services, but his social care support will come from the adult social services team. I mean, I sort of tend to think there's education department, children's services, which is social care, and adult social services, which is social care. But of course, sometimes, very often, children's services includes adult and it includes education and children's services. So the education element of the education healthcare plan will remain with whoever is responsible for education, either children's services or education department, if they're separate, if this makes sense. But the social care part of the education healthcare plan will be under the adult legislation, the adult social services responsibility. So you've got to look at the plan should have been changed, so that the social care element, which would have been under H, the Care Act, the Children Act, and the Chronic Sick and Disabled Persons Act, that transfers to adult social services, but the education element remains with whoever in the authority is responsible for education. Does that make any sense?
Yes, yes, sort of. It's still confusing because it's the social care side of it. Obviously, it's the educational need side of it. It's sort of like I'm finding it really difficult to understand because obviously the Children and Families Act extends support to 25.
Yeah, yeah.
And but
But the
obviously my son, the transition sort of didn't happen properly for my son, and he's put into adult services. He had his speech and language support. There's a gap. It sort of fell away. He still needs it, but it is actually a social care need because it's part of his well-being, and he can't talk well to people and make friendships and stuff.
yeah.
He has Down syndrome. So there's been a real problem, and it's been addressed in his care plan as part of his needs, but nothing's happening to put it right.
Okay,
So it's
well,
like an ongoing issue it's like drift. It's not
if he needs
being supported.
speech and language therapy because of he's got an education healthcare plan, then that will normally sit with the education department, and they will have to secure that. Whoever is and wherever the education department sits, it will be their responsibility. And sometimes education will be part of children and young people. It can't be adult social services. Adult social services don't do speech and language therapy. If you've got an education healthcare plan, it will be the education, wherever education sits within the local authority, it will be their responsibility. If there isn't an education healthcare plan, then it will normally be the responsibility of the NHS.
That he has an educational healthcare plan.
And that specifies speech and language therapy.
Yeah, well, there's been a lot of opposition about his therapy because he's got all the reports and the assessments and the evidence, but they basically don't want to, this is
It's
gap,
ever does.
between
It's
the
ever
services.
does.
Yeah.
But if it's on the education healthcare plan, it's got to be provided by the local authority, full stop. And in a way, your complaint should be made to the local authority. Let's say it's North Yorkshire, saying this is on the education healthcare plan. It's not being provided. I'm making a complaint to the local authority. And in a way, you don't want to have to get into, it's not your problem as to which department, which budget it comes from. If it's on the plan, it's got to be provided, full stop. And regardless of whether the person's 14 or 23, if the plan is still being maintained, then that's got to carry on. That shouldn't change at all with transition.
So in terms of like transitioning, the code of practice says that they're not set in stone, and it should happen at the best time for the person. Well, obviously for my son, because of that speech and language side, it hasn't been good for him.
But there's no transition for the transition. There is no transition for speech and language therapy. It's only when you're moving between the Children Act and the Care Act, and the speech and language therapy is under the Children and Families Act. It's under the education set. So there's no transition.
So, okay, thank you.
Yeah, sorry, I should have made that clear. The education element, there is no transition. I mean, except when you get to 25.
Yeah. So if you invite a social worker to the educational healthcare review, is that person supposed to be somebody from the adult side or the children's side then?
Once they're over 18?
Yeah.
Well, normally it will be the adult side, but if they haven't actually handed the baton over, the convenient moment hasn't arisen, then it could be children's services. But somebody who's responsible for social care should be there. I mean, normally they don't turn up, as you know, but you can say, well, you didn't turn up and we agreed this, so you can't object to that. But you should have a representative from social services. In theory, it should be adults, but if you haven't, that convenient moment for the transition hasn't happened, it should then presumably be children, but there should just be somebody that is holding the social care portfolio.
Okay, thank you.
Yeah, sorry, I mean, it's a real mess. Um, do carers have a right to be able to access work under the Children Act, i.e. the local authority should provide a PA support? Yeah, parents have a right to work. I did look at that. I'm pretty sure in the last talk I did a few weeks and months ago on that. There is a very important case against Kent where the Ombudsman really spelled that out, where the mother was unable to work flexibly. And so that is covered. I'm pretty sure I covered that on the last occasion. I can send you the, if you go to my website, and when I started the talk this morning, I said that on my website, if you go to publications, I've got a guide to carers and their rights, which I publish ever so often, and you can just download that. And if you download that and you look at, I think it's chapter 12, but it's one of the later chapters. There's a chapter on parent carers' rights, parent carers under the Children Act. And that there's a very powerful case against Kent that's there, which says, yes, of course, the local authority should provide support to enable the mother to stay and work. So yes, because what I would have said, and I think I would have said this on the last occasion, I'm pretty sure I did, that under the parent carers have a right to be assessed under Section 17ZD of the Children Act. And when you are assessing a parent carer, a parent of a disabled child, you assess, the obligation is to promote their well-being, and well-being has the same meaning as under the Care Act, and well-being includes the right to work, education, training, and recreational activities. And there's a powerful 2016 Ombudsman case against Kent, which really spells that out very succinctly. So I can email Sarah that Kent case, but I think it was covered in the last talk, but I'll make a note of that. Is that all right? It's a very important point.
Yeah, that was myself. Thank you. I've just got the local authority are refusing to provide a PA. They've said all that they can provide is a taxi escort for him. He's only 15 at the minute, but I'm also a disabled parent carer. And they're saying no, they're not going to provide a PA. I think they're trying to pass it to social care at the minute, which I'm still waiting on a carer's assessment on that one.
Okay, if you access the book, it should help you load it, and it's a PDF, so it should be readable.
Yeah, I'll have a look at that.
Yeah, well, best of luck.
Thank you.
Then we have a 17-year-old who requires support, especially as she goes into adulthood. However, at the moment, she has nothing. She does have an EHCP plan. We are linked to social worker, but this is because we have a special guardianship order, and he purely deals with adult. What I don't know what ASF is. Adult services. I don't know. Sorry. He has been invited to meetings, but always says that's not his job. How do we now go to find the right social worker support? Well, I'd just make a complaint to the local authority. I'd make a complaint, and I'd make it to adult social services, children's social services, and I'd probably send it to the chief executive as well. Just saying, we have got these needs. We can't work out whether it should be provided under the Children Act, the Chronic Disabled Persons Act, the Care Act, or Children and Families Act. our brain hurts. This is your authority. Clearly, this our 17-year-old has these needs, and nobody in your responsibility is grasping the nettle and taking responsibility. It's sort of not me, it's somebody else. So I just make a complaint about them not working together. There's no way you should be able to, deal with that. If she's got an EHCP plan, if there is social care going in under that, when she's 17, it will be going under the Children Act. I suppose ultimately it's the adult social services to undertake one of these transition assessments. So they're probably the ones that are responsible, although children's services should have alerted them to this. But I'd be inclined to make just a general complaint. And again, the Accessing Public Services Toolkit, which you can download from my website, will sort of talk about this area where you're not sure if it's education or children's services or health services or adult social services. You just complain against them all. I'm sorry about that. But it probably is a failure of the adult social services to do the transitional assessment. Rob, does PIP come under assessment? No, PIP doesn't. PIP is completely different. It's a Department of Work and Pensions assessment, and it's nothing to do with local authorities at the moment. So it's another branch of the welfare state, another silo that you have to be assessed in, but it's nothing to do with what I'm talking today. The key point is just because you're getting PIP doesn't mean that local authorities don't have to provide support services. And then, yeah, and Rob, you make the point about anxiety is often dismissed as a valid reason. Yeah, that's a good comment. I agree with you completely. There's another comment about PIP and DLA. They're just Department of Work and Pension benefits, and I'm not dealing with that today. Mental capacity, Viv, you mentioned. I'm going to talk about that now. So I'm going to roll up my sleeves and get on with that, but please come back on any of those points that if I haven't properly discussed them, or we can look at them briefly at the end, or I've got to finish at 12:30. Got another meeting. So I'll load up the PowerPoint for hopefully. Can you see the slide now?
Yeah, we can. Oh, we did.
Can you see the mental capacity decision-making slide?
We can see the slide. Yeah, it's just not. It's not. That's better. Yeah, that's okay. Good.
That's good. Thank you very much.
Thank you.
So we're going to plow through this again. I'm doing it at speed, but please make comments. I won't be able to read the comments, the chat, but hopefully we'll have a few minutes where, Sarah, you might be able to just read them out or summarize any particular questions rather than comments. So mental capacity and decision making, largely looking at young people, but also adults. The problem with the mental capacity legislation, it's not a problem, it's a problem with a complex area like having the ability to make an informed decision. The law sort of deals with that in different ways, because age is a determinant, but it's not a fixed determinant. So of course, a newborn baby will not have much capacity to make informed decisions. But once you get to a certain age, you do acquire the ability to make informed decisions. But of course, that will vary from young person to young person. So what we have is some age lines, but they're not fixed. They're what we would call presumptions. So people under the age of 16 are presumed to lack the ability to make informed decisions unless they demonstrate otherwise. So that was said in a case called Gillick and Norfolk and Wisbech Health Authority many moons ago. So the presumption is young people can't make decisions, but in individual cases, if the evidence shows that they can, then they are able to make binding decisions on certain things. The Wisbech case, the Gillick case concerned a young person agreeing to have contraceptive advice from a doctor without the mother being told, Mrs. Victoria Gillick. And the court said, yes, if she had acquired that maturity and decision-making skills, then she could make the decision and it didn't have to be one made by her mother. But the general presumption is under 16, people don't have the capacity, and therefore it's done by the person who has parental responsibility for them. In most cases, there are exceptions to that, and I'm not going to be able to go into that. You've got a pretty weird sort of situation for 16 and 17-year-olds. Effectively, everybody over 16 or over has the capacity to make the full range of decisions. At law, those decisions count. Of course, there are restrictions on people marrying over 16 but under 18, and there are legal restrictions, and you can't be an MP if you're 16 or 17. So there are some legal restrictions, but in general, on all other areas, people can make decisions if they're 16 or 17. The only hiccup on that is a curious one, which is that people 16 or 17 can consent to medical treatment. They're presumed to have the capacity to consent to medical treatment, but they're not presumed to have capacity to refuse medical treatment. And again, that's something that we could spend all day on, so I'm not going to go into it. But generally, people 16 or over are assumed to have the capacity to make decisions, but they may not have that capacity. But the presumption is they do. And once you're over 18, you're presumed to have the capacity to make the whole range of decisions, unless it's shown that you don't. So really, the watershed moment is 16. There is a code of practice to the Mental Capacity Act. It's still in the 2007 mode. And if you are interested in a particular mental capacity issue, it's the go-to document. It's a very good document. It's going to be updated. It should have been updated a long time ago, but they're very minor updates. It's a very good document. You can download it. I don't know how many pages. It's extensive, and it will answer, I don't know, 80% or 90% of all common questions. Now, as was said in the chat function, capacity is complex because it's what we call matter specific. Whether somebody's got the ability to make a decision about something depends on the type of decision you're going to make. So the more complex the decision, or the more serious the consequences, the more carefully the court will scrutinize whether the person's got capacity. And that can be quite subtle. So sometimes they will ask, have you got capacity to handle money? And the answer is, well, how much? Because as I say there, if you just got some pocket money, basically, or you're just getting a small amount of an allowance, and it's £10 a week, then you probably may have capacity to do that, but not if you suddenly inherit £500,000 or £1 million. They're very different decisions. One doesn't really have many consequences if you spend your money incorrectly. The other one does. So the consequences, the court will carefully analyse what you need to know. Anybody who's over 16 will be assumed to be able to do what they like with money. Anybody under 16 won't. But the presumption will be more carefully analysed the greater it is. And that's one of the curiosities, about, I was saying, if you're over 16 but under 18, you can consent to treatment, but not necessarily refuse treatment. And that's because the consequences are very different. So if a consultant says, well, this is an operation and it's got an 80% chance of succeeding, and I think it's in your best interest, and you consent to that, then the consequences are likely not to be grave. But if there's something that you are refusing and it's certain that you'll die if you don't have that treatment, the consequences are completely different. So one has got to look at the complexity and the consequences often of making a decision. To agree to take penicillin is a different decision to agreeing to have open heart surgery and so on. All of these things we could spend a day on. All of these things, we've got students who spend 3 years on their PhD writing. All of them are incredibly arcane and potentially deep questions. So if you've got capacity to make a decision, then you make a decision, and it can be sensible, stupid, it can be whimsical. That's one of the joys of being an autonomous individual. If, however, the view is that you lack capacity to make a decision, then that creates an obligation on other people to make a decision in your best interests. This is what the law says. It's highly controversial in many disability areas, but this is what the law says, and therefore this is what the courts will do. So people under 16, largely it will be the parents' right to make those decisions. And in the Gillick case, the court said that just because you're under 16 doesn't mean that you can't make decisions. It's just that the people assessing this must carefully sort of question you on what you understand, your understanding and intelligence. So where somebody is under 18 and they don't have the capacity to make the decision, then it will be the parents. And the parents must make that decision in relation to the best interest of the child. And if there's a disagreement between, say, a doctor or social worker with the parent's decision, then in general, the local authority or the health body will have to apply to the court. They can't just override it, because Section 3 of the Children Act says it's the parental responsibility to make those decisions. So the Mental Capacity Act applies to people 16 or over. It's got various key issues. Section 1 includes principles, which we'll look at. And then we have the idea that capacity is matter specific, which we've already looked at. That also involves understanding the consequences and ability to rationalize. We'll probably look at that very quickly. And then we look at best interests. I'm going to have to skate over some of this because we're going to need to finish on time. So Section 1 is just a set of principles, and they're very important and they're very valuable principles. And the core principle is that everybody 16 or over is presumed to have capacity to make the whole range of decisions. And if anybody wants to suggest that they lack the capacity to make those range of decisions, that individual or social worker or doctor will have to produce matter-specific evidence about that individual that rebuts the presumption. Just because you make an unreasonable decision doesn't mean you lack capacity. Sorry, the second one is that you're not to be treated as unable to make a decision unless all reasonable steps have been taken without success. So some people may not appear to have capacity, but then because they have a communication difficulty, but intellectually they are quite capable of making that decision, it's difficult communicating that. So there must be all reasonable steps taken to communicate with that person. And sometimes, it's only going to be the family that really does understand and properly communicate with somebody. Just because you make an unwise decision doesn't mean you lack capacity, but it will be evidence. If that's the only evidence, then it's not going to be enough. But if you repeatedly make decisions that are bizarre, that cumulatively could come to the decision that you lack capacity in relation to a particular issue. If you are considered to lack capacity, then the decision must be made in your best interests. And there's also about the question of whether you, we'll look at best interests separately because it's an interesting idea. I've already talked about the more serious the consequences of making or refusing to make a decision, the more anxiously the courts will look at that. In order to make a valid decision, in order to have capacity to make a decision, you need to do the following. 4 things. I think it's 4 things. The presumption is you can make a decision, so you don't have to prove each of these. But if somebody wants to say you lack capacity, they'll have to show that one of these 4 things can't be done. The first is that you've got to understand the information relevant to the decision. You've got to understand it. So if you've got fantasies that or phobias, not phobias, but fantasies about the just the call it misconceptions of reality, then it will be shown that the court will say, well, this person really doesn't understand the factual context of this decision. You've got to be able to retain that information long enough to make the decision. So you don't have to have, you can have short-term memory problems, but as long as when you make the decision, you hold in your mind all the relevant information, that's going to be good enough. Particularly, I suppose, with older people who have short-term memory problems, one of the things to do is to ask them, let's say on 3 separate occasions, to make a decision. And if on each of those occasions they make the same decision, then it may be that they are retaining it enough if they to make the decision. The courts have said that part of the decision making is not understand. You've only got to understand the information. You've got to retain the information, but you've got to have some ability to exercise judgment. And those cases come about because of people that have total phobias. There's a very famous case of somebody who had a complete phobia for injections. And so she would always refuse to have an injection at any stage. And it was quite clear that she understood that if she didn't have the injection, she would, it was to have an operation, she would die. She didn't want to die. But she would always, no matter what the issue was, refuse an injection. And the court was saying, well, she can understand the information, you contain it, but she can't exercise any judgment because she is like a bunny in the headlights. She is terrified. And so that took away her ability to do the third limb, to weigh the information as part of the process. These are all highly controversial principles, but this is the way the legislation's been drafted in the UK. And the fourth limb is that you must communicate the decision. So you can have somebody who's what we would call locked-in syndrome, who appears not to be able to understand, even to blink an eye, but they are actually hearing everything, they can understand everything, they can make a decision on everything. They simply can't communicate. And that can also occur if somebody who has very complex communication difficulties is rushed into hospital in an alien area, and an emergency operation is required, and there's nobody that can communicate with that person that's got those skills, but something has to be done urgently. Then even though they could communicate, if their family or whatever was there, that covers the treatment decision. If you lack capacity to make a decision on a specific issue, so you can have capacity to make decisions on A, B, C, and D, but you lack the capacity to make it on E, because it's matter specific. If you are shown to lack capacity and it's accepted that you do lack capacity to make a specific decision, then the law requires that that decision be made in your best interests, and that's dealt with by Section 4 of the Mental Capacity Act. And it's got a sort of it's got a checklist of things that have to be done. There are certain decisions you can't, even if you lack capacity, best interest doesn't get you over the line. So you can't consent to marriage, consent to sexual relations, you can't consent to divorce, you can't agree to your child being adopted, because those are things you literally, that can't be done in your best interests. So the sort of checklist for best interests, first of all, is, can we put off the decision because you've got temporary loss of your capacity, but you're going to regain it? So is this a decision that we can defer? And that will often apply to people who basically are on drugs or alcohol, but also people who have, let's say, a profound depression, have been detained under the Mental Health Act, who are not lucid. But it's thought that they will recover their lucidity, their ability to make decisions. So we'll put it off. The point I should also have made is that the Mental Capacity Act has nothing to do with the Mental Health Act. So the mere fact that you're detained under the Mental Health Act, you're still presumed to have capacity to make all sorts of decisions. The fact that you've been sectioned because you're a risk to yourself or others, and you have a mental health condition, doesn't rebut the presumption that you have capacity. So the first question is, this person lacks capacity, but can we put it off because they may recover their capacity in the near future? Obviously, if you've got profound learning disabilities, that's not going to happen. Even if you lack capacity, it's incredibly important that you understand what the individual wants. They participate and they let you very clearly know what they want to happen. Even though that's not a capacitated decision and it doesn't determine it, clearly it's always going to be better to go with what the individual wants rather than go against those wishes, unless it's demonstrably not appropriate. Then it's very important to understand their past wishes and feelings, what they would have done. This again is pretty controversial, but often it occurs with people who are Jehovah's Witness, who lack capacity, they're unconscious, and they need an operation that involves a blood transfusion. And now it's very clear that they wouldn't want that. That's something that should be considered. It can be overruled. There are Jehovah's Witnesses who fall very gravely ill, are told they need a blood transfusion to live, and agree to it. There are people who hold some beliefs more strongly than others. So it is something to be put in the balance. You then must seek out the views of people that know that person, what I call here significant others. Anyone engaged in caring for the person or interested in their welfare. And this is very often the issue when you have a learning disabled young person over 16 or over 18, and the local authorities say, well, it's not your decision to the parents anymore. We decide what's in that person's best interests. And that's just nonsense, because the decision has got to go through this checklist, and whoever makes the decision, and it won't necessarily be social services, it could be a dentist, it could be a hairdresser, it could be a physician. Very often it's the family that decide these best interest decisions. It depends on who's going to enact it. So if it's a tooth extraction, it'll have to be the dentist that makes this decision, and so on. But a local authority has got to take into account the views of people who are engaged in caring, so that would be a personal assistant or whatever, or the people who are interested in the welfare, and that, of course, is going to be families. And there must be a presumption that families know best, because they have continual involvement with that person, and they understand and communicate. So even though somebody is above the age of, they're above the age of 16, the family's views are going to be incredibly important in deciding what's best for them, because they will know often that person better than anybody else. If somebody lacks capacity, there are certain limited situations where they will have a right to an advocate. They are pretty limited. They're called IMCAs, independent mental capacity advocates. That means if they're unbefriended, they don't have anybody suitable, any family or friends that are willing and able to do that. And it's a significant decision, and a significant decision is either a decision to provide or withhold serious medical treatment, and that's defined in the guidance, or they're going to change the person's address for a particular period of time. Then, unless there is somebody who is family or friend prepared to advocate on their behalf, the local authority must obtain the view, or the local authority or the NHS, because it could be a health service, must obtain the view of an independent mental capacity advocate. Lasting powers of attorney. So if whilst you are capacitated and over 18, you can fill out a form saying, if I lose my capacity, I want this named person to be my attorney and to make these decisions on my behalf. There are two types of lasting powers of attorney, LPAs. One will do financial, and that's by far the most common. If I lose capacity, I want my wife, or I want my accountant, or my daughter to handle my financial affairs. And the other is personal welfare. If I lose capacity, I want this person to decide these personal welfare decisions on my behalf. Not money, but where I live, who I see, and so on. We'll look at that. If you want to appoint both, you have to fill out two separate forms. All of this stuff can be downloaded from the internet, from the Public Guardian Office's site. These forms are very, I think, pretty straightforward. They're a bit like, probably not as daunting as filling out a passport application. They have fees, but they can be waived. Well, the power of attorney fees can't be waived, but the deputy fees can be if you're on low income, if the incapacitated person is on low income. And as I say, you go to the Public Guardian Office of the Public Guardian, and you've got this very simple system for generating them and creating them. It's online, it's very accessible. So if you want a financial lasting power of attorney, that person can do property and financial affairs. So they can buy or sell property, open a bank account, receive benefits, deal with tax affairs, invest money, make limited gifts, pay for private and medical affairs, and so on. All of these things must be done in the individual's best interests. What they would have done, what is in their best interests. All of these must be involved discussion with the nearest and dearest. Personal welfare LPAs can make decisions about where the person lives, decisions on diet and dress, contact decisions, consent or refuse medical treatment, and so on. These are quite big decisions, but an individual can give that to, whilst they've got capacity, can sign a lasting power of attorney, personal welfare, and name somebody who is their personal welfare LPA. You complete forms you can download. There's quite a lot of sort of interesting case law. So there's an example of somebody who appoints somebody to be her lasting power of attorney to manage her financial affairs. But it's quite clear that when she appointed that person, she was unable to manage her financial affairs. And so the question was, did she have capacity to make the lasting power of attorney financial affairs? And the court said, well, yes, she probably did, because she'd given somebody the power to make a decision she couldn't make at that stage. She had a level of confusion meant that she couldn't handle her affairs. She was a wealthy person, had lots of stocks and shares and different bank accounts, things like that. And she knew that she didn't have capacity to do that. So she had that insight. But she also knew that she had somebody who she trusted, and she wanted that person to take over that role for her. So she had enough capacity to make that decision, even though she didn't have enough capacity to manage her affairs. So the question is often, what is the question? Do they have capacity to handle money? No, that's not the question. Do they have the capacity to manage £10 is the question. And in this case, does she have the capacity to appoint somebody to do what she wants, which she would do if she had capacity? And she did have enough money to appoint. She did have enough capacity to understand that this was the person she trusted and she wanted to handle their affairs, even though she couldn't do the transaction that she wanted that person to do, i.e. handle her affairs. So there is some quite complex, well, there's a huge amount of complexity in some of these small decisions. So somebody with significant learning disabilities could appoint their parent or somebody else to be their lasting power of attorney to manage their financial affairs, even though they themselves are incapable of managing their affairs. So the court is saying appointing somebody to be our LPA doesn't require a lot of understanding, but it requires enough understanding to know that you're appointing somebody, that you trust that person, that you can't revoke it because once it's done because you lack the capacity to undo it. And there's a procedure for creation and registration. Sorry, I seem to have, yeah. If you lack capacity to make a lasting power of attorney, so let's say you've had a stroke or your dementia's got to a stage where you are no longer to make, say, financial decisions, and you no longer really recognize anybody, so you can't ask somebody to do it because you really don't, your capacity's gone so far, then you can't make an LPA. And in that stage, you're going to need to have somebody appointed as your deputy to make the decision. And that will mean an application, that individual will have to make an application to the Court of Protection to be appointed that person's deputy. But that again is fairly straightforward if it's financial. It's much more difficult if it's about personal welfare issues. So the court will want to know that this person doesn't have enough capacity to make an LPA and has never made one. Deputies if they apply to the court for authority, the court will check out, the public guardian office will check out whether they are fit and proper people, and will give those people as limited as powers as possible to do just what is the bare necessity. But they can give that person the right to make personal welfare decisions as well as financial decisions. And there's a website, you just go to the that website, and it's very straightforward. So I've got a friend who I'm her deputy for, and I just go to there and fill out the form, fairly straightforward. Appointeeships are something completely different. They are if the individual is getting social security benefits, personal independent payments, or social income support or something like that, then the Department of Work and Pensions can just pay the money to somebody else who's an appointee. But that's just administrative. There are no court proceedings in that. The Department of Work and Pension just nominates somebody that they can make the payment to. And if there's any problem, the Department of Work and Pensions can just rescind that. There is a thing called deprivation of liberty safeguards, which I'm really not going into, but this is where somebody lacks the capacity to decide where to live. And they are not free to leave where they're living. So they are continually supervised, being watched all the time, and they're not free to leave. And so often you'd say, well, what would happen? So you've got people in a care home, say elderly people with dementia. What would happen if they tried to go out the front door? And the answer is they would be escorted back. They are not free to leave. They don't have the capacity to decide to remain there. Therefore, they are subject to a deprivation of their liberty, and a procedure then has to be followed, which is known as a deprivation of liberty safeguard, a DOLS. It's pretty administratively complex. It requires an application to be made to the DOLS officer of the local authority, and various procedures are followed. There needs to be an assessment of whether the person lacks capacity, an assessment of whether they have a mental disorder of some description, like dementia or something, and then there's got to be a best interest decision. There's a few other things as well, but those are the key things. Is it in their best interest to remain there, or is there another place they could be which is less restrictive? There's a procedure to change the DOLS to LPSs, Liberty Protection Orders. Sorry, this shows me, oh yes, as of July, the government's not specified when they'll come into force. We've got a new government, so they may come into force. I don't think they're going to come into force very soon. There'll be a lot more training to go. It'll be quite expensive procedure. Just very, very quickly rounding off law reform. You'll have this there. The Law Commission is looking at reforming the law for disabled children as social care, not mental capacity law, just social care law for disabled children. Some of the language used in the Children Act is very outdated. It talks about handicapped children and things like that we wouldn't talk about. So it'll be just making it more appropriate. There was supposed to be a report out in spring this year. We're now told it'll come out in September. These are just things for you to consider. You'll get the PowerPoint anyway, but one of the big ones would be national eligibility criteria. But we've done a lot of research on this. So if you go to my website, you'll see a lot of research that we've done in this field. So I've powered through that. I'm sorry it's been so quick. I've got 5 minutes. I'm sorry to say, I'm going to have to log off and at past because I've got another meeting just shortly after there. Sarah, are there any chat things that I really ought to look at in these 5 minutes?
There was a couple of questions, but
Yeah.
they've just chatted amongst themselves, the attendees. So unless anyone wants to approach Luke now just to get clarity on those questions, just pop your hand up. But no, other than that, Luke, we're quite quiet at the minute.
I'm sure they're beaten into submission. I'm sorry, it's been so much data. A lot of it, I'm sure you're all very familiar with, but hopefully some of it's been useful. Thanks for listening. Oh, Kerry, I think, has got a hand up. Is that right?
Yes.
Hi,
Yes.
yes. Hi, I'm Kerry. It was just something that I put at the end of the first half of the session was regarding, I mean, there's a lot of rights around carers, being able to say that I want to work, I want to study, I'm not, I can't care.
Yeah.
But what happens when there is no care out there? We can't get the services, we can't get the carers, the agencies, particularly in rural areas where we don't have any infrastructure with public transport. So unfortunately, we may have a lot of rights, but those rights don't serve if we don't have the services to serve those, if you know what I mean.
Yeah, I do. I often ask the sort of Richard Branson question. If Richard Branson was living in his house next to you, and he had a disabled young person, could he get that support that he needed? And the answer is, well, yes, of course he could. So most councils, have got as many millions as he has. So is this really there are no carers, or they're not really paying them enough, or they have arbitrary limit that will only pay £12 an hour or something like that? Once a need has been identified, it's got to be met. And if there are, you could get a carer, but they want £25 an hour, well, then it's £25 an hour. So, what I normally do in those situations is saying, look, this is needed. I want to go back to work. I want to do this. I want to do that. You're saying that it's very difficult. Well, I want you to come up with a plan within 3 weeks, explaining how within 3 months I can go back to work. You're going to advertise, you're going to do this, you're going to recruit, you're going to work out how much people want, because you can't have arbitrary limits on what you pay per hour. You're going to contact agencies. Well, maybe the agency staff will do it, but they want to be paid travelling time as well as care time. And your authority says, we don't pay travelling time. Well, I'm sorry, you're going to have to pay travelling time. There's an ombudsman case on that. So it's a question of saying, look, this is my right. I can see you've got a problem because, there isn't a shortage. But, that's clearly soluble. If you were a wealthy person, you would be able to do this. And I'm requiring you to go to the same extent, to start advertising, recruiting, doing this, talking to providers. It's the best that you can do, I think. But normally local authorities are not doing the best that they can do. They can just say, well, there's a supply side problem, we can't help you. And they're very happy there's a supply side problem because they make money out of not having to spend it on you. Does that make sense?
Yes, yeah. Yeah. I was going to say that they have said, they will meet all the extra costs, but we're still 2 years on and still not getting anybody answering our advertisements, unfortunately.
Yeah, well, why don't the local authority? You don't have to do it yourself. Why doesn't the local authority do it? Why doesn't you just say, I don't want a direct payment, I just want somebody to do this. The local authority is under a duty to do this. You recruit somebody, and if you can do that, then maybe I'll take a direct payment. But it's your job to sort this out. And I go to the ombudsman and say, yes, there's a supply side problem, but they're not, clearly this is, they have the resources and the power to do these things. And they've got a duty to do it. And I just simply don't believe that you can't get these people. I'm sure Richard Branson could.
He'd probably offer them more than 25 quid, Luke.
Well, then you have to do that, that's how you get a chief executive. You pay them more than 25 quid, They don't have problems filling that post, so I don't see why they should have problems filling your post. No, I should just say, this. Anyway, that's all I can do. Yeah, if there's a really supply side problem and you simply can't do it, then that is a problem. But the courts will want to have it explained to them that everything is being done that can be done to meet that need. And if you can't, then, but I find it difficult to believe that after 2 years you can't find somebody.
Yeah.
I'm going to have to love you and leave you, I think. And I'm sorry about that. I hope I've covered, I hope I haven't covered it too quickly.